them. All right, so let's take it from there. Then please, let me warn, nobody is expected to send in attendance to the chat box unless you are told to do so. Many of you, it is the attendance that is most important thing to you. Don't do that in my class. If you do that, then I will note that you didn't attend the class, and I will ensure that the attendance did not count for you. If I want attendance, I know how to get it, so you don't have to disturb the class by sending in attendance. All right, so I was explaining common law to us. So I said that it grew from the custom that is, or norms, custom common to the people of England and Wales. And then common law originated in the early Middle Ages. This is part of the history of common law that you need to note. It originated in the early Middle Ages in the King's Court. That was the name of the court as at that time. And apart from the King's Court, another name that can be used for it is the Curia Regis. So apart from King's Court, the other name for it is Curia Regis. Curia is spelled C-U-R-I-A. Okay? So that is another name for the court where common law originated from. Then, it is the part of English law that is derived from custom and judicial precedent or judicial decision rather than statutes. Okay, common law is the part of English law. Now, when we talk about statutes, we can refer to those laws made by the organs of government that is saddled with the responsibility to make law. So those ones, they are the ones that enact, when they enact a law, that is, they pass a law, you can refer to it sometimes as statute. So, but the point we are making this morning about common law is that this common law did not originate from statutes, that is, such laws that were made by the law-making body. Rather, they were gotten from judicial precedent. Judicial precedent is past decision of courts, which sometimes we refer to as case law. You must have heard us discuss case law. That is the judgment of a particular court in a previous matter. So, apart from the fact that common law was derived from the custom of the English people, it is also from judicial decisions. So, judicial precedent, which is also known as judicial decisions, states that decision of a superior court are binding and must be followed by inferior courts in appropriate cases. So what we mean is that in Nigeria, for example, we have different courts. We have the Supreme Court, which is the highest court in the land, followed by the Court of Appeal. So this judicial precedent as a doctrine states that once a higher court, like the Supreme Court, gives a judgment on a matter, that judgment can be applied to a similar case in a lower court. And mind you, in Nigeria, after the Supreme Court is the Court of Appeal, followed by the High Court. In some cases, you will see that they also have another court known as Federal High Court. They will put them at the same level. Now, that's what we call hierarchy of court. That is from the highest to the lowest. So what the doctrine of judicial precedent or stare decisis is saying that once a court, a higher court, reaches a decision in a particular matter, if a similar matter is coming up in the court below, once they are of the same fact, the judgment in that case, that previous case, can be applied to it. And that's why we call it judicial precedent. So this method, this style of using a previous decision on the current case is of a common law origin, meaning that it came from common law. So therefore, you can say that common law is where the doctrine of judicial precedent came out from. And we have explained to you what the doctrine is all about, which is simply that the judgment of a court, of a higher court, is binding on a lower court in a similar case where they have the same facts. That is what it simply means. So, this whole idea of common law or judicial precedent that we said originated from the common law system was developed by the King's Bench. Apart from the King's Bench, the Court of Common Pleas and Courts of Exchequer, all of these courts were known as the King's Court. You remember I said that at the beginning, which I also said other name for it is Curia Regis. So this common law we are talking about grew from all of those courts, which makes up the King's Court. The other one you say Nigerian courts. Nigerian courts includes Supreme Court, Court of Appeal, Federal Court, High Court of a state, High Court of Federal Capital Territory, Magistrate Court, Customary Court, Sharia Court, and so on. the courts that were in existence as at that time in question were known as, number one, the King's Bench. Number two is the courts of common plea. And lastly, courts of exchequer. All of them were referred to as the courts of the King's Courts. So, somebody wants to ask a question? I will see. Yes.
Sir, please, you say court of head checker?
Exchequer. Exchequer is spelled EXCHEQUAR. You will notice that I'm a bit slow in teaching you because this course will be a bit technical for you. So that's why I'm taking it very slowly. This is not the way I will teach law students who may ordinarily have a foundation in what we're talking about. Afolabi Adenike, yes, you have a question?
Yes, sir. You mentioned three courts, but I only got two: the Court of Exchequer and the Court of Common Pleas. Please, sir, can you mention the third one again?
King's Bench. Okay. So these three courts were also referred to as the courts of the king before the king himself. That is another way they refer to these courts. That is because the English Court of Common Law in English legal system, showcases all of these courts that we have listed. And that is where common law originated from. So, and all of this development took place between early 12th century to 13th century. And the Court of Exchequer was an English appellate court for common law civil action. What that means is that for those of you who may have had little experience with our legal system, if a court of appeal delivers judgment and the parties, maybe one of them was not satisfied with the outcome of the judgment, they can appeal to the Supreme Court. So in that way, we refer to the Supreme Court as appellate court because it's a court that you can appeal to when you are not satisfied with the decision of the court below. So one of the appellate courts in the
sorry that I'm joining. I have to
please, just 1 minute.
We have an outstanding sectorial topic to be treated, and that is the chemical management. But I'm going to divide that so that we can progress. I understand your timetable will soon be out. So let's see if we can finish before then. Then I can still come back to the topic and put it through. Under the chemical management, there is all sorts of environmental impact assessment,
Hope you can still hear me.
Yes, sir.
Yes, sir.
Yes, sir.
All right.
Yes, sir.
Yes, sir.
So I said that the Court of Exchequer was an English appellate court for common law civil action, meaning that every action that is civil in the sense that it's not criminal, is referred to as civil action. So when a person is not satisfied with the decision reached by maybe any court, you will need to go up to a higher court. And the court of exchequer was in that position, stood in that position to receive appeal from the lower court. So, but in 1873 to 1875, there was what was known as the Judicature Act. Hello?
So please, can you repeat what you said now?
Okay, all right. So I think the thing muted. So I was talking about the fact that the Court of Exchequer was an English appellate court for common law civil action before the reform of the Judicature Act of 1873 and 1875. And this was what was simply in vogue at that time. It was a system of law that, again, I repeat, was derived from those courts, talking about common law. And in common law, under common law, if you have a case, before your case can see the light of the day, it must fall within an existing writ. Existing writ in the sense that it is a case that the magistrate court must have dealt with, that the common law court must have dealt with before you can bring a case. Let's say, for example, if you have a case, you and somebody, you had an issue, and then you want to file an action against the person, and maybe the case has to do with breach of contracts. You gave him money to supply some products, and he did not supply. That is breach of contract. Before you can be able to file a case at the common law court, you must have a case that is already like breach of contract case that is there before. And that is what we call writs. That has become a writ that is already in that court. So your case must be similar, must be able to fall within that case. Otherwise, there will be no case for you. And this is one of the things that this common law is known for. And that's why we say that common law is a very rigid court or a very rigid system of law. Do you understand? So, and if you do not have, if there is no existing writ that your case can fit into, then you will not be able to get remedy. And because of that, it means that if I must go to court to seek remedy, to get redress, I must pray that I already have a case that has been decided by that court that my writs can go into. So, and another problem with it is that even when that writ what we call it is already existing, where your claim can fit into, there's no guarantee that you will get an effective remedy, because the way the law works there is that it is very strict. So it is either you are lucky. So it's more like a case of being lucky. So if you are not lucky enough, then you will not get remedy. So what we're saying in essence is that common law system was a very rigid system that only allows for its rule. There is no room for flexibility there. And that's why we say that in practice, common law is very strict, very formal, and full of legalism. It was also rigid and defective in a number of ways. Please, just a minute. There is a message from your coordinator that it appears that you're supposed to have a class with him. Let me just respond to him, please. All right, thank you. So me and Oluwole, we really need to look at this timetable together so that we don't have clashes. So I said one common thing that is common with the common law is that it is very rigid. Very rigid. And it's not easily amended. So it's a bigger issue with this system. For instance, it adheres strictly to what we call privity of contract and do not recognize the concept of trust. What do we mean by this? Privity of contract is a legal term in law of contract that unless you are part of the contract, simply put, I'm just putting it in a simple, unless you are part of the contract, you don't have a say. But you know, sometimes you may not be directly part of the contract and the outcome of the contract may affect you. For example, if Mr. A wants to sell something to Mr. B, and because Mr. B is already expecting that Mr. A will sell to him, he has made an arrangement with Mr. C to buy from him when eventually sold. Now, B has paid Mr. A. Mr. A is not supplying. You know, C, who has also paid B, will eventually lose if A did not give it to B. But under common law is saying that since the law does not recognize that third person, it is just the A and B. But whereas in other form of law, it is not so. The law may tend to be flexible to consider the interest of the other person who has already, put his feet into that contract. So what it means is that the system itself does not give room for flexibility. And then it works strictly by whatever it is written down. In our contemporary time, the kind of law we engage may not, give room for us to engage strictly by the rule, because sometimes the court may see reasons to deviate slightly from the rule in order for justice to be done. Because the purpose of the court is not just to hold a session, but to do justice to whatever case that is before it. So, in brief, that is what common law is. Common law grew from the custom of the English people, the people of Wales as well, and then it developed from the Middle Ages in the court that we refer to as the King's Court, which comprises of the King's Bench as a court, comprises of the Court of Common Pleas and the Court of Exchequer. But in all, we said that common law is very rigid in its application. Before you can have a successful outing there, your case must fit into an existing claim that is already there. And that the fact that your writ or your claim falls into an existing claim in the court does not guarantee you any success. Because if the rule that is applicable is not properly followed, then there is no remedy for that individual. So in summary, that is what common law is all about. Then the second aspect of this classification is the civil law. But before I take that, let me listen to Afolabi, who is raising her hand.
Thank you, sir. You said before that if you bring a case to a common law court and there is no existing case that is similar to your case, then the case might not see daylight. So how did they gather the previous cases if it was so rigid like that? How were the other cases brought to court and made into reads?
Okay, that's a very beautiful question. It shows that you are really thinking about it. Now, some of those reads that were there, some of them were formed by reason of the custom that they were used to. As time progresses, they begin to set rules. Previously, I understand that you can become a professor even without having a PhD. So if somebody is now saying that before you can become a professor, you must have a PhD. So the question you now ask is that, so those that became professors before, how did they become professors? That is one of the better ways that I can explain what you have asked. But one way or the other, they were able to formulate those writs. And as time progresses, as occasion demand, they are now say, okay, we have sufficient writ, we have sufficient claim. Any claim that must come after now must fit into this existing claim. But of course, this issue happens to be one of the major weaknesses of the common law courts. That why can you say that you must have an existing writ before you can, a litigant can bring a case before the court? Do you understand now? So that's the explanation I can provide based on that. Okay, so
Thank you, sir.
yes, Mawusi.
So before the message from the class coordinator came in, you were saying something about in 1873 to 1875. You did not complete it, and then when you came back, you now moved to the common law is very rigid.
Yes, I said that the Court of Exchequer was an English appellate court for common law civil action before the Reform of Judicature Act of 1873 and 1875. What that means is that after the reform of the Judicature Act of 1873 and 1875, some things changed, which may include that the Court of Exchequer, which is one of the courts that common law originated from, is no longer the appellate court, or not the only appellate court in the common law system. You get that now?
Yes, thank you, sir.
Okay, Oluwaseun.
Okay, good morning, sir.
Good morning.
Yes, sir. So I'll be asking my question in form of an illustration.
Okay.
Okay, so okay, let's say common law is just like using a family recipe that has been passed down from generation to generation, while
Okay.
civil law is like playing a board game where the rules never change. So are we saying that the recipe that has been passed down to from generation to generation, that there cannot be glitches or there cannot be limitations to what you can add or what you cannot add?
Well, that's one of the weaknesses of the system. The system adheres strictly to what has been handed over. Do you get the point? So what has been handed over from time immemorial is what the system require that you stick by, unless there is a further development or changes altering what has been done. Do you understand now?
Yes, sir. But what if like the facts do not align with the previous cases? Would the judges still like follow the previous case, or they would simply follow and use their own discretion?
Apart from the fact that there must be an existing writ, what it means is that the fact of the case and the judgments arrived at, the fact of the case must be similar to the one that is coming. Do you get it now?
Yes, sir.
And that's why we are saying that if the fact of the case, which constitutes your own claim, does not fit into that existing writ, then you're not able to get remedy.
So that means justice is denied.
Yes, and that's one of the major problems with the common law system. The rigidity does not give room for judges most times to apply their discretion. I gave an illustration where I said A and B and C did some transaction. If we were to be in other system of court, they could as well say that, since Mr. A has promised Mr. B, Mr. B has now went ahead to boast to a customer that my goods is arriving, and that customer, which is C, has paid. Therefore, if Mr. A should breach the contract with Mr. B, the court will reason that Mr. C has automatically suffered. If Mr. C has suffered as a result of A's failure, then A should be held liable to some extent. That is what, other courts will do. But common law will not do that. Common law will ask, is this Mr. C part of the contract from the beginning? If it's not part of the contract from the beginning, forget it. Yes?
All right, sir.
Who
Thank you,
else?
sir.
Yeah. Who else?
Sir,
Who
sir,
else?
my question is that if the common court doesn't if the common court doesn't accept any, like you were saying that if the case is not similar to what they've done before, that they might not attend to it, something like that. So if the common court does not attend to those cases, will the lower courts be able to do them? Like, will they be permitted to do it? Like,
The rule is also applicable to the lower court, not just the court that is considered as the superior court. Do you understand? So it's a rule that applies to all the court, not just one court alone.
okay.
All right.
Thank you,
So
sir.
let's move on because of our time. The second part of this first classification, which is common law and civil law. Let's look at the civil law aspect of this classification. Civil law is the whole of private law and public law, except criminal law. Civil law is the whole of private law and public law, except criminal law. Now, you may want to also, or you notice that the whole thing is becoming a bit complicated because you want to ask, what is private law? What is public law? There are some laws, there are some kind of laws too that are classified as private law. For example, law of contracts governs relationship between two parties who are engaging in contracts. So that is one. Then, when you look at criminal law deals with punishing those who are committing crime in the society, even though the individual is not even the state or the government, but the government will arrest the person and then prosecute the person. That is criminal law and it falls under public law. But our focus here, in order for you to have a better understanding, is that civil law means every other law that falls under private and public law except criminal law. And it went further to say that all laws, excluding criminal law, military law, or emergency law, are civil law. So if you want to look at civil law generally, once you pack all the laws together, let me use that word, and you remove military law, you remove criminal law, you remove emergency law or martial law, every other law is civil. So civil law deals with the rules for dealing with rights and duties between individuals. That was why I was explaining to you that law of contract governs relationship between two people. So we can say that an example of civil law is the law of contracts. So I repeat that again, that civil law deals with rules for dealing with rights and duties between individuals. It is concerned with dispute between citizens. The purpose being to enable people to enforce their rights, to redress a grievance, or to recover property for their own benefits. If you bought a property and then somebody is claiming the same property that you have bought with your money, of course, the property law will apply to it. But what is the focus? The focus is so that you can get your own land back, so that you can enforce your right to own land. So that's what we're saying. Generally, civil law deals with the rights of citizens or addressing disputes between citizens in order for them to enforce their rights or to be able to correct an error or an injustice that has been done to them. So that is what civil law is all about. So we have what we call municipal law or law of states. These are examples of civil law. So you need to know that examples of civil law include municipal law or law of states. And mind you, every other law that deals with relationship between citizens, that addresses concerns as it relates to right of people, falls under civil law. The only law that is, or the kind of law that does not fall under civil law is military law, criminal law, and what we call martial law. So, therefore, civil law is a law that defines the rights and duties of persons to one another. Civil law is a law that defines the rights and duties of persons to one another. Again, it is a system of law that deals with private relations between members of a society and also offer legal remedies that may be sought in a dispute. So any case or any kind of law that deals with the private relations between members of the society, just like the example I gave for law of contract, property law, and so on and so forth, they are examples of civil law. And meaning that any law that helps to obtain legal remedy or get some form of compensation or redress, all of it falls under the civil law. Again, civil law entails a system whereby an individual who is injured by a wrongful act of another can be compensated for the damage which he has suffered. If a party to a transaction has suffered a loss due to the fault of the other, it is civil law that helps to provide remedies for such a person. This remedy may come in different form. If the person has collected money, the court, the civil court, can order the person to refund the money. Or the civil court can compel that person who has collected money to supply a particular product, can compel him that at all costs, go and look for these products and supply. This is how the civil law operates. Examples of civil law includes number one, contract law, like I mentioned earlier, law of torts, tort as in T-O-R-T-S, law of torts. Another example is land law. At least if you have not heard of any law before, you'll have heard of land law. Another example is family law. And of course, when you hear family law, you know that it relates to relations, the issues that pertain to people, and therefore they are issues or cases that fall under this class of law known as the civil law. Then, like I said earlier, civil wrong can lead to recovery of money or enforcement of rights, but not punishment. Civil wrong can lead to recovery of money, just like I explained that Mr. A has collected money from Mr. B, and Mr. A refused to perform the contract, that has amounted to civil wrong. The remedy that such an individual can get is either to ask Mr. A to refund the money, or that Mr. A should go and look for that product at all costs and deliver. Lastly on this, according to A.O. Sonny, he defined the word civil law by saying that civil law has several meanings, but that it may mean the law that is not criminal law. Just like we explained before. Any law that is not criminal law, that is not military law, that is not martial law, can mean civil law. And generally, they deal with the rights of individuals in the society and helps them to obtain remedy where the one is needed, and also help them to enforce their rights when it is required. So you look at that critically, you will see that this is civil law and the other part is common law, even though they have different names. Some of the laws practiced under common law are also referred to as civil law. Every law practiced under common law, except criminal law, they are civil. And therefore, that's why we are discussing the two of them together in this form. So, somebody is raising a hand. I will take question now and close for today. I know that Muslim brothers and sisters will want to go for Jumat. So let's quickly take the questions before we go. Yes.
Good morning, sir.
Good morning.
Please, sir, when do a court use common law or civil law? Like in a country in Nigeria, like Nigeria now, I think they do civil law and they do common law. Like when do they say that I will use civil law now, or they will use common law now?
There's no time you say that, because most of the laws that we practice, they are civil. The only thing is that depending on the issue you have, if somebody has stolen your property, that comes under criminal law. And under common law, there's also there's also criminal law underneath it. So there's no time you will say this is common law. All of those system of law are practiced here. As a matter of fact, later on you will see that they are being fused together, but the explanation we will give you will provide better explanation to you. Next person.
Good afternoon, sir. Sorry, good morning, sir.
Morning.
Sir, if private laws and public laws are aspects of civil law, then why is it discussed as a separate classification? Why aren't they just discussed as types of civil law?
We are still going to discuss them separately, but they are examples of civil law. Even if we discuss them separately, which we will do, by the time we discuss them separately, you will understand what we're talking about. We will still say that this is private and property law, which we say they are examples. We cannot conclude the discussion on private and property law without saying that they fall under the broad umbrella of civil law.
Okay, sir.
Yes. Next person, Oreoluwa. After Oreoluwa, we have Sonny.
Okay. Sir, I wanted to ask, I want me to research about strict liability and principle of neighbor, what do you call it again? Neighbor principles. So I wanted to ask that, are those civil law or common law?
They come under the law of torts. And we have said law of torts is an example of civil law.
Okay, sir. Thank you, sir.
Yeah, welcome. Lastly, Sonny, let's take you.
Okay, sir. Good morning, sir.
Morning.
So my question is actually under the common law. So I want
Okay.
to ask, even with the weakness that the common law has, do they still practice it?
Yes, but there is a modification now, as you know, because of series of development. By the time we are discussing common law and equity, you will understand what we are saying. It was the harshness of that common law that led to another system of law known as equity. Okay? So you will know whether they are still applied till now or not when we are discussing common law and equity. So,
Okay, sir.
yeah, some two people have raised their hand again. Rocky
Thank you,
back.
sir.
Yes, Rocky back and Nwoko. Chinyere, or yes, Chinyere. Or yours raising your hand.
Yeah, good morning, sir. Sir,
Morning.
my question revolves around common law. So, common law and judicial president, they're kind of similar, but an exception in judicial president. Judicial president um can be accepted if they distinguish if the facts are distinguished. But common law, does it accept distinguishing facts, even if there is an existing case before? Can the facts not be distinguished at all?
Well, for the under the common law, the rules are strict. Is it either your case fixed or not? The rule is strict. But
Sir?
that can you hear me?
Yes, I
I
can.
said the rules are strict under common law. But when you have such a case, when we talk about distinguishing of fact, it happens in a court where equity is applied. Okay, because equity gives room for flexibility to look at the
Okay.
reasoning and all of that. So later on, you will understand it better. I think it's because you were part of a class where we talked about judicial precedent as a source of law. That's what we got that. That's also beautiful. At least you were able to apply it. Yes, Oreoluwa.
Sir, please, that judicature action, please, can you spell it?
Judicature acts.
Okay.
Judicature
Yes.
acts. Spelled as pronounced. Judicature.
Judicature.
Yes, acts.
Okay, sir. Thank you, sir.
All right. Okay, so thank you very much for listening today. Do enjoy the rest of your day and have a wonderful weekend ahead. Thank you.
Thank you, sir.
Thank you, sir.
Thank you,
Yes,
sir.
sir.
Thank you, sir.
Thank you, sir.